Welcome, everybody. Apologies, they just had some trouble getting me on as a panelist. A hearty welcome to everybody to the first of the series of webinars that we're doing as Pillar 3 of the NSP GBVF Collaborative, dealing with different aspects of the 3 Gender-Based Violence Amendment Acts. First, I just would like to hand us over to the administrators working hard on the side, organizing everything for the House rules. Thank you. Doesn't seem like anybody is coming in, so I think most of you would not be able to put on your cameras and your speakers, but you do have the chat function. There's also the Q&A function. Please put your questions to the panelists and the presenter in the Q&A session. In the chat function, you can indicate who you are. I trust that despite possible load shedding and other issues, that you may be able to have the full benefit of this webinar. I would like to hand over to our keynote speaker firstly, Deputy Minister of Justice, Mr. John Jeffrey. Welcome, DAM.
Thanks very much, Mrs. Wessels, and good morning, everybody. I'm not really the keynote speaker as far as I know. I'm just doing the introduction. So let me proceed. Good morning to everybody on the platform, and welcome to our first July webinar series on the 3 new GBV Amendment Acts. The aim of the webinars is to cover the salient changes being introduced by these acts and to complement the work being done by the various government departments in ensuring their readiness for the implementation of these acts. That's the amendment ones, obviously. The webinar series for the 3 amendment acts will run until the end of this month and will be co-facilitated by the judiciary, government and civil society organizations. It will unpack a variety of salient changes and introduced by these acts, and you're invited to attend all the sessions. Today's webinar will focus specifically on the new domestic violence regulations, and in particular aims to alert the public and stakeholders of the call for comments on the draft regulations. Last month, the Department of Justice and Constitutional Development invited interested parties to submit written comments on the draft regulations, directives, and tariffs under the Domestic Violence Act. The regulations are issued by the Minister of Justice and Correctional Services and are intended to repeal and replace the regulations which were published in November 1999. In addition, the Director General of Justice and Constitutional Development has also prepared the directives for clerks of the courts as contemplated in Section 18A, as well as the tariffs of compensation payable to the electronic communications service providers, as contemplated in Section 5B9 of the Act. The draft regulations, directives and tariffs are available on the website of the department, and the closing date for comments is the 8th of July, this Friday. Now, maybe just to add that usually more time is given for comments. However, we are under pressure to have this act or these acts implemented in effect, with the President in fact saying that similar information was already given to the multi-party Women's Caucus in Parliament, that these acts would be implemented by the end of July. So hence there was a shorter period for comment. And hence, to try and compensate for that, these seminars are being arranged to try and encourage people to make input. Many of you are familiar with the path the 3 amendment acts have taken. In January this year, President Ramaphosa signed into law the 3 new acts aimed at strengthening and efforts to end gender-based violence with a victim-centered focus on combating this pandemic. The President has assented to the Criminal Law, Sexual Offences and Related Matters Amendment Act, the Criminal and Related Matters Amendment Act, and the Domestic Violence Amendment Act. Before we look at the draft regulations, it's perhaps best to take a step back and look at the Domestic Violence Amendment Act itself. The main aim of the amendments was to make the Domestic Violence Act more user-friendly and suitable to the needs of society. Violence is not always physical, it can take other forms. And that's why amended legislation includes definitions such as controlling behavior and coercive behavior, and expands existing definitions such as domestic violence to also include spiritual abuse, elder abuse, and/or exposing or subjecting children to certain of the listed behaviors. It also introduces online applications for protection orders and imposes obligations on functionaries in the departments of health and social development to provide certain services to victims of domestic violence. The Act makes it compulsory for certain functionaries who, in the course of the performance of their duties, obtains information which causes them to believe that a child, a person with a disability, or an older person is a victim or complainant. And it requires them to do a number of things such as complete a report and do a risk assessment. Another adult person who's not a functionary but who knows, believes or suspects on reasonable grounds that an act of domestic violence has been committed against a child, a person with a disability or an older person must report such knowledge, belief or suspicion as soon as possible to a social worker or the police, and failure to do so constitutes a punishable offence. You may remember in the original bill that was introduced, there was provision for this duty to apply not just to the category of people, children, people with disabilities, etc., older persons, but to all people. But that was basically dropped after considering inputs that were made in the parliamentary process. A peace officer must, without a warrant, arrest any respondent at the scene of an incident of domestic violence who they believe of having committed an act of domestic violence, and must render assistance to the victim, such as, for example, to make arrangements for the complainant to obtain medical attention. A complainant who shares a joint residence with a respondent may apply to court for the issuing of a domestic violence safety monitoring notice. The court may, in terms of this notice, order the police to contact the complainant at regular intervals to inquire about the complainant's well-being and to regularly visit the joint residence and see and to communicate in private with the complainant. The court must order a member of the police to seize any weapon in the possession or under the control of a respondent, if so specified in a protection order. And the court can also order electronic communication service providers to disclose certain information if it relates to domestic violence. The new draft regulations are necessary in order to give practical effect to these changes in the law. The Amendment Act provides that the Minister may make regulations regarding any form required to be prescribed in terms of this Act, and regarding financial assistance to be provided by the state to a complainant or respondent who does not have the means to pay for fees of any service in terms of this Act, and also to a witness who attends any proceedings in terms of this Act. The Minister may also make regulations regarding the granting of legal aid at state expense in appropriate cases, in consultation with Legal Aid South Africa, to the complainant, respondent, a person with a disability, an older person, or a child, to assist them with an application for a protection order in terms of this Act, and also regarding any matter required to be prescribed in terms of this Act, and which the Minister deems necessary or expedient to be prescribed in order to achieve the objects of this Act. Mr. Mokulu Bete will be going into details of the regulations in his presentation. I think it's important to emphasize that the regulations are aimed at making the process easier and more user-friendly for complainants. And I think one of the difficulties with lawyers and wanting to ensure that you've got all the nuts and bolts is that sometimes we make things more complicated. So that's where we particularly rely on civil society. Many activities will now be accessible through a cell phone, laptop, or computer and can be done at any time, which means that a complainant will not have to take time off, travel long distances, or stand in queues to be assisted. It also means not having to explain where a complainant is going or ensuring greater privacy. Many of the regulations are not necessarily new, but it's important to highlight that additional insertions have been added to strengthen the provisions. For example, Regulation 11 dealing with the issuing of an interim protection order is not a new provision, but additional insertions have been included to provide for the manner of service of documents on the respondent. If the court issues the interim protection order, the clerk of the court must immediately notify the complainant thereof telephonically or electronically. All operational aspects contemplated in the Act must be in place before the Act can be put into operation, and this is the pressure to complete the regulations. This relates to the regulations and the directives that must be published by the Minister and the Director General respectively. Also, the forms must be available electronically, and the online portal must be in place once the Act is put into operation. It's therefore crucial that we have the regulations and directives in place, and the stakeholders and the public are given an opportunity to submit their inputs on the drafts. As you had heard earlier, that the deadline is this coming Friday, the 8th of July, for the attention of Mr. Mokulubete. And I think it's on the advertisement where they're to be sent to, can be posted, although we'd be running out of time for that, or hand delivered or emailed. And Mr. Mokulubete, I think, should put his details up on the chat box. And he can also be contacted directly on a landline and a cell phone. And I think, again, Mr. Mokulubete, if you can put those up. We want to encourage stakeholders and members of the public to submit their comments so that we can ensure that we have regulations which make a meaningful impact in preventing and combating gender-based violence and femicide. We have to make the process as user-friendly as possible so as not to cause any further trauma for the complainants, and also to ensure that they get the support and the services that they need. I will now hand over to Mr. Mokulubete. I thank you.
Thank you very much, Deputy Minister. Mac, while you're waiting to put up your PowerPoint presentation, this is, as indicated, part of the consultative process as well. So you're more than welcome to put your comments, your inputs also in the chat or in the question and answer box. Thank you, Mac. If you can just put it into presentation mode. Your PowerPoint is up.
Thank you very much, Ms. Wessels, and thank you to the Deputy Minister. I hope you can all hear me and you can see my presentation on the screen.
Yes, you're loud and clear on the side.
And I don't know about my video.
Maybe because of connectivity issues.
Yeah, my video is on from my side, but it doesn't seem.
Yeah, I see you. Now I see you and your PowerPoint is up.
I can't see myself, so I don't know how I look. Yeah, okay, thank you very much. And thank you very much to everyone in attendance on this platform. It is really an honor for me to be doing this presentation on this very important aspect of the work that we do as the department. By way of an introduction, my name is Makubela and my surname is Mukudubete. I'm a state law advisor here at the Department of Justice and Constitutional Development, specifically in the Legislative Development branch of the department. The Deputy Minister has briefly introduced, in his introduction, mentioned the Domestic Violence Amendment Act that we have promoted as the department, and it's a very important piece of legislation because it gives some of the important pieces of gaps that existed in the existing Domestic Violence Act, so as to make sure that the processes of obtaining the benefits emanating from this Domestic Violence Act are actually for the benefit of the society, especially the victims of domestic violence. The important aspect that is brought about the Amendment Act is specifically in relation to the amendment of Section 19. The Deputy Minister has touched on that a little bit, to an extent that the Amendment Act is amending Section 19(1) of the current Domestic Violence Act to empower the minister to make regulations regarding the forms that must be used, the financial assistance that must be provided by the state to a complainant or respondent, to a witness who attends the proceedings, and the granting of legal aid at the expense of the state to the complainant, respondent, a person with a disability, an older person, or a child. And the Amendment Act has brought about this an open-ended provision that empowers the minister to make any regulation required relating to any matter that is required to be prescribed in terms of the Act. And also the minister is given the powers to make the regulations that are deemed necessary or expedient to be in order to achieve the object of this Act. Now, the important thing is to recall that we have in the existing Domestic Violence Act a definition of prescribed. That definition actually empowers the making of regulations. And this regulation will be made in terms of this Section 19(1) as amended. And as a result of the Amendment Act, many regulations have now to be made. And these many regulations, coupled with the form that accompany those regulations, have necessitated the need for us as the department to ultimately repeal the existing domestic violence regulations of 1999 and replace them with the new regulations that we will be talking about now. Now, with all this, I would like to go to the regulations as prepared by us as the department. However, I will not go to each and every regulations that we have drafted, but I will just isolate a few of those that are important, that I think are important to be drawn to the attention of the society. And obviously, each and every single regulation is equally important. And we are not placing any hierarchy to any of those regulations. Now, with regards to Regulation 1, it's the regulations that deals with the definitions. And these definitions are aimed at facilitating the interpretation of the regulations. And I'm isolating two of the most important and significant definitions that we have come up in these regulations, being the definition of electronically and the online portal. I'm isolating this because, as you will see throughout the regulations, and as you will have heard through the promotion of the Amendment Act, we are introducing the electronic platform in terms of which the domestic violence protection orders are going to be applied for and processed. So there will be a lot of use of electronic platforms, and also the online portal, which will be the portal that is giving an entryway to the citizens to apply for a domestic violence protection order. And obviously then in a long time, we have seen the advent of the use of electronic medium, which have actually overtaken most aspects of our lives. And this has become an important feature that we need to make use in the regulations in terms of the processing or the application for protection orders. So we have introduced this definition of electronically to mean in relation to service of any documents to serve by any electronic medium, including facsimile, electronic mail, SMS, MMS, or other social media. With regards to regulations 2 and 3, these are not new provisions, but are currently existing in the current regulations. And also, as the Deputy Minister has mentioned, not all these regulations are new. We have retained some of the regulations that are currently existing, and we have improved them to an extent that is necessary. And we have added some more so as to close the gaps that are existing in the current legal dispensation in as far as the regulations are concerned. Now, we will recall that Section 282 of the Act requires that a report be prescribed to be completed by a functionary who believes or suspects that an act of domestic violence occurred, and also the manner of submitting that report to a social worker or a police. Now, with this provision in mind, we came up with this regulations that is Regulation 4 to provide for a Form 2, which will be used as a report by a functionary. And this report, once it has been filled in by the functionary, it may be submitted by hand or electronically to a social worker or the police. So that is where the issue of electronically comes in, as I talked to when I talked about the definitions. So this form will be transmitted to the social worker or the police by hand or electronically. Obviously, the introduction of electronic means does not necessarily do away with the manual submission of documents. So the manual submission is still available, so as to avoid instances where electronic means are not available, as it normally is the case in some instances. Furthermore, the Section 282 of the Act requires a functionary to conduct a risk assessment as contemplated in Section 18B, and after the evaluation of the risk assessment, to provide to or refer the complainant for further services as contemplated in Section 18B. This Section 18B is a provision that requires the various departments that are mentioned in that section, particularly the Department of Health, the Department of Social Development, Basic Education, Higher Education and Training, Communication and Digital Technologies. Those departments are required to prepare the directives that are going to guide the functionaries who are employed by those departments when it comes to dealing with the victims of domestic violence. So those directives will guide the functionaries as to how to deal with the victims of domestic violence in terms of conducting the risk assessment and also the referral, the provision or the referral for further services. Now, with this section in mind, we have included a provision in the Regulation 4 for that require the provision of such services or the referral for further services. Therefore, the complainant must specifically be advised by the functionary of the necessity of the referral for further services, and actually must be referred for further services by that functionary. Now, Section 2B2 of the Act requires that a report be prescribed that must be completed by an adult person who knows, believes, or suspects that an act of domestic violence has been committed against a child, person with a disability, or an older person, and also the manner of submitting that report to a social worker or the police. So, in a similar vein with the report that is required to be submitted by the functionary, then there is the requirement that requires an adult person to report a suspicion or knowledge or belief of commission of acts of domestic violence. And these are particularly in relation to a child, a person with a disability, or an older person. So in order to facilitate this reporting requirement, a Form 3 has been designed for these purposes, and equally it has to be submitted by hand or electronically. Regulation 6 provides for a form. That form is a list that a peace officer must provide to a complainant or a person acting on behalf of the complainant. So this list contained in Form 4 of the regulations will contain the details of accessible shelters and public health establishment. However, we have decided not to include the inclusion of physical addresses in that list, because we believe that once it can land in the hands of a potential respondent, then they will be able to easily determine where the victim or the complainant will have been sheltered, because the list will have contained the address of the shelters. However, with regards to the public health establishment, there will be the physical addresses as required by that Form 4. Now, this list may be given to a complainant by hand or electronically, or otherwise the complainant may be directed to the website where this list can be accessed. In addition, we have a form that we have designed, which is a Form 5, which is a notice that a peace officer must hand to the complainant. And this notice explains the rights that the complainant has under the Act. And the peace officer must also explain the contents of this notice to the complainant and the available remedies and right to lodge a complaint in terms of the Act. The peace officer must also provide further assistance as contemplated in Section 8B of the Act. This assistance will be inclusive of a referral of the complainant for medical assistance, a referral to the police or social worker, to a shelter or for an alternative accommodation, or even to court to apply for a protection order. These are the most important aspects that the peace officer must render to the victim of the domestic violence. Furthermore, this list and also this notice must be available on the website of the department so that anyone can be able to access it wherever they need that. Furthermore, Regulation 7 is not a new regulation. It's actually a reenactment of the existing Regulation 4. However, we have included additional provisions such as the submission of the application form, which is Form 6, to the clerk of the court. It can be done in person, it can be done electronically or through the online portal. So one of the requirements of that form must state the court having jurisdiction at which the complainant will be able to or prefers to attend the hearing of the matter. So in short, there will be a provision where the complainant, when filling in this application, will state which court will the complainant prefer to attend when the matter is called for a hearing. However, this court should be within the jurisdiction. Cannot choose any other court. However, it must be the court that has jurisdiction either over the complainant or the respondent. The regulation also provides for a Form 7, which must be filled in by a victim or a complainant when giving consent to the bringing of the application for a protection order on behalf of the victim or the complainant. You'll remember in terms of the Amendment Act, there's an expansion of the provision that empowers a specific person who has an interest in the well-being of the complainant to bring the application on behalf of the complainant. Currently, there's no form that can be used as a form of consent for uniformity. And as a result, we have designed this Form 7 so as to be used for a person who gives a consent for the bringing of the application for a protection order on their behalf. Regulation 9 sets out specific documents that must be captured in the repository. You will see in the regulations and also in the Act, a certain documents must be put or must be captured in the repository. Not everything or every document that relates to the protection order in terms of the Domestic Violence Act will be captured in the repository. Only specific documents will be captured in the repository. Otherwise, the repository may be overburdened and may not be user-friendly if everything and every document is captured in the repository. Regulation 10 provides for a Form 9, and it is used in applying for a safety monitoring notice. And we also designed a Form 10, which is a form of a court order that will be used by the court when the court grants an application for a safety monitoring notice. You will remember this actually is a new invention. We have heard in practice that many applicants or complainants who have applied for domestic violence protection orders will actually be victimized even if they are in possession of the protection order. So now we have come up with a provision which is contained in the Act that will try to a certain extent alleviate that problem of the victims be victimized whilst they are in possession of the protection order. So now this provision is improved in terms of the details that are contained in the Regulation 10 that requires that an assigned member of the police should frequently check on the well-being of the complainant. So once the court issues the safety monitoring notice, then the clerk of the court must serve the issued a notice to the relevant station commander, and this can be done by hand or electronically. That station commander must immediately upon receipt of the court order assign a member of the police who must within 24 hours serve the court order on the respondent either by hand or electronically, and immediately contact the complainant The complainant must be notified of the service or non-service of the court order telephonically or electronically. So this provision also deals with the gap that existed currently in practice, in terms of which now the complainants do not have any knowledge as to what is happening in relation to the application for protection orders. And in some instances, the complainant will be obliged out of their necessity to go to court and make inquiries in relation to the application for a protection order. So now, what we have done is to make sure that the complainants are notified electronically or telephonically as to what is happening in their application for protection order. So this notice, that is the safety monitoring notice, is one of those notices that the complainant must be notified about, where the court has issued the application for, or has granted the application for the issuing of the safety monitoring notice. Now, the form of a report must be prescribed that the station commander or their delegate must file in relation to the safety monitoring notice. So once the member has been assigned, that member will be required to submit a report to the court in terms of the activities of that member. So the Form 11 has been designed for use by a member so as to that form requires that a certain information to be captured by that member in terms of their activities relating to the safety monitoring notice. This include when and how did the member contact the complainant upon the receipt of the safety monitoring notice, when did the member communicate with the complainant, if the complainant appeared to have been hurt or threatened, and state what advice was given to the complainant, including the referral of the complainant for medical assistance to a shelter or for the opening of a criminal complaint. The member of the police will be required, and this is contained in the form, the member will be required to report on every contact made with the complainant and the outcome of the monitoring of the complainant's safety. Now, going to Regulation 11, which deals with the issuing of the protection order. This is the new, not a new regulations. Additional insertions have been included to provide most especially the manner of service of documents on the respondent. If the court issues the interim protection order, the clerk of the court must immediately notify the complainant thereof telephonically or electronically. So this is one of the gaps that we have identified in terms of the complainant not being aware of what is happening in terms of the application for domestic violence protection order. So now the complainant must immediately notify the complainant, and this must be done telephonically or electronically. Now, Regulation 12 is also a new provision. We have additional insertions there regarding the manner of service of documents on the respondent, and that if the court does not issue an interim protection order, the clerk of the court must notify the complainant telephonically or electronically that the court has not issued the interim protection order, that the court has issued a notice to show cause. This will be contained in Form 13, and also of the date of hearing. So this will apply in the instances where the court has not granted the interim protection order. So the clerk of the court must notify the complainant telephonically or electronically that the interim protection order has not been issued, and of the notice to court to show cause that has been issued and the date of the hearing. Regulation 13 provides for the manner of service. The certified copies of the interim protection order, and most especially the original warrant of arrest, must be served on the complainant. This will enable the complainant to be in possession of the original warrant of arrest, because the complainant will use the original when going to the police station to report any breach of the protection order by the respondent. So the complainant will be in possession of the original warrant of arrest that must be submitted to the police. The Regulation 14 provides for a subpoena. We have two different types of subpoenas here. Form 14 is the subpoena that will be used by a person who is being subpoenaed to appear in court as a witness. And there's a Form 15 that provides for the subpoena of a person to provide a book, a document, video, photograph, audio clip, USB stick, or any object. Now, this regulation also set out the information that this subpoena must contain. In particular, the subpoena must include the date on which there will be an appearance in court, the specific court, and even the court number, because obviously then in court you will not know which specific courtroom the witness will have to go to. So the subpoena will have to contain those particulars for the witness to be able to have knowledge of. Now, the original subpoena must be served on the person affected thereby by hand or electronically, and that person must be given a copy of the subpoena. However, the subpoena must be served 10 days at least before the date of hearing. Now, the person who has been subpoenaed to deliver the book, document, or an object that is specified in the subpoena is required to submit those to the clerk of the court before 12 o'clock midday on the day before the date of hearing. And this can be done by hand or, if practical, electronically, or also if practical by uploading the book, document, or object on the online portal. Now, there's a provision to accommodate those witnesses who have got the objection in the production of the subpoenaed book or document or object. They must notify the clerk of the court by hand or electronically, and also before 12 o'clock on the day before the date of hearing, of the intention to raise an objection to the production of those, and also the grounds upon which the objection is based. Now, Regulation 15 prescribes a Form 16 that must be used by the court to request relevant particulars from the electronic communication service provider, and that the clerk of the court is required to serve the request for that particulars by hand or electronically to the electronic communication service providers. So the relevance of this provision is where there is the court needs to know who, especially in cases where there's been a disclosure or a distribution on an electronic platform, and the court will need to know who is the person who submitted or displayed or disclosed that offensive electronic communication. So the court is empowered in terms of this regulation to send a direction to the relevant electronic communication service provider to give the requested particulars in relation to the identity of that person, their addresses, their names, and all sort of information that the court will need in order to identify that person. So that is all about that form. There's a specific form so that each and every court can be able to use a single form uniformly. Regulation 20 prescribes a form which is Form 23. This form will be used by the court to order the removal or a disablement of access to the electronic communication. So the court can give an order that an offensive material be removed or access thereto be disabled. So this the court will use Form 23 for that purpose. And the court will also direct the clerk of the court to immediately serve that order of on the electronic communication service provider, and this must be done specifically electronically and not later than 1 hour after the order has been made. So this talks to the agency of the removal of the offensive material on the electronic on the electronic platform. This regulation also prescribes a Form 24 to be used by the electronic communication service provider when they apply to set aside or to amend a court order. So it doesn't mean when there's this Form 23, then the electronic communication service provider is left in the woods. They are able to, in terms of this Form 24, apply to the court to set aside or to a certain extent apply to amend the court order that has been given as contained in Form 23. That application must be made within 14 days and must be served on the clerk of the court by hand or electronically, but the court must be satisfied that there is good cause that has been shown to set aside or to amend the court order. Now, Regulation 22, the court must, at the hearing of the application for a final protection order, inquire as to who of the parties must refund the tariff paid by the state to the electronic communication service provider. Now, this comes back to that form where the electronic communication service provider will be required to give certain particulars to the court. Obviously, those details must be paid for, and there's a tariff that will apply uniformly in terms of which the electronic service communication provider will be paid. So there's a standard a tariff that is set for payment for that purpose. However, the court will be required to conduct an inquiry to determine who should, at the end of the day, pay for that charge of the electronic communication service provider. However, as a starting point, the court can be able to order the state to pay for that. And at the end of the matter, then the court can determine who should refund the state for the amount paid by the state to the electronic communication service provider. So this is what is covered in this Regulation 22. Regulation 23 is a provision that attempts to incorporate the new section 6012B of the Criminal Procedure Act. This act or this amendment has been brought by the Criminal and Related Matters Amendment Act, which is one of the act that is still to be put into operation together with this Domestic Violence Amendment Act. This act or this Amendment Act introduced this provision, which provides that if the court is satisfied that the interest of justice permits the release of an accused on bail in respect of an offense that was allegedly committed by the accused against any person in a domestic relationship with the accused, and a protection order has not been issued against the accused, the court must, after holding an inquiry, issue a protection order. So this is the quick and the easier manner of obtaining a protection order for the victim when there has not been a formal application for a protection order in terms of the Domestic Violence Act. Regulation 24 prescribes a Form 31 for extension or discharge of the interim protection order. If the protection order is not discharged, the parties must be notified of the extended date of hearing. Currently, there's been a gap in the Domestic Violence Act where there have not been provision as to what happens maybe then in cases where the complainant has not been present in court and only the respondent has been present in court, or also in the instances where both the complainant and the respondent have not been present in court. So the Amendment Act has closed that gap and required that a form be prescribed in terms of which the parties will be notified if they have been absent in court of the next date of hearing. Regulation 25 is not a new provision. However, additional provisions has been inserted regarding the capturing of the issued warrant of arrest on the Integrated Case Management System, the ICMS, the uploading and capturing of the warrant of arrest, that is Form 33, together with any relevant information relating to it on the integrated repository. Remember, I did mention that not all information or document relating to the domestic violence will be captured in the electronic repository. So some of the information or documents will be captured in this ICMS. Certain documents, as specified in the regulations, will be captured in the repository. Then this Form 33, which is the warrant of arrest, is one of the documents that are going to be captured in the repository. This Regulation 25 also provides for the submission of a copy of the warrant together with a copy of the protection order by hand or electronically to the police station chosen by the complainant. Regulation 27 is also not a new provision. Certain additions have been inserted there, and particularly that the affidavit, which should be Form 35, must state that the respondent, this relates to the affidavit that must be submitted by the complainant when there's a breach of the protection order by the respondent. So this affidavit must state that the respondent has contravened a prohibition, condition, and obligation or order contained in the protection order. The specific prohibition, condition, obligation, or order that has been contravened by the respondent must be stated, and also the manner and in which and the extent to which the respondent has contravened the prohibition, condition, obligation, or the order. Regulation 29 is a provision that requires the clerk of the court to, by no later than 24 hours, to inform the station commander of the police station servicing the area where the respondent resides, studies, carries on business, or is employed, and also the National Commissioner of the South African Police Service of the final protection order issued against the respondent. There's a Form 37 that is designed for this notification for the police, so as to also promote uniformity against across the country in terms of the submission of this information to the police, and this is to enable the police to conduct an inquiry, and particularly the National Commissioner to conduct an inquiry in terms of the Firearms Control Act of 2000. Regulation 32 is not a new provision. It deals with the service and filing in general. Certain provisions have been included, some of which are the establishment of the return of service. Currently, there is no form court in terms of what has been done in relation to a particular document. So we have designed this Form 40 to be used by the clerk of the court, the police, and the sheriff. And the return of non-service must state the reason for non-service and the attempts made to effect a successful service on the of the document. So this Form 40 will require to state if there's been no successful service of the document on the respondent as to what attempts have been made to try to serve the document in question. Also, one of the additions is a service or submission of a document electronically is effected by sending the document to an electronic mail address, facsimile, or social media platform, page, or number of the intended person. The other one is that a person sending the document electronically to any person in terms of the regulations must obtain a delivery report, a screenshot, a facsimile transmission report as a confirmation that the document was delivered to the electronic mail address, facsimile number, or platform, or social media platform, page, or number of the person intended to be served. Furthermore, if any document requires to be served by hand and the respondent cannot be located or has moved to an area that is served by another police station or by another sheriff, the member or the sheriff must file with the clerk of the court a return of non-service stating that very fact. And lastly, if any person intended to be served cannot be served in any manner in any of the means provided in the regulations, the clerk of the court must immediately, after receipt of the return of non-service, notify the person requiring service to be able to apply for a substitute service. So a substitute service is an application that will enable the court to give an order that suggests an alternative manner of service in the instance where the manner that are available in the regulations are not successful in terms of the service of the document on the intended person. However, the court must be satisfied that service of any document cannot be effected in the manner prescribed by the regulations. So all these manners that are available in the regulations must be unsuccessful so that the court can be able to provide for or authorize an alternative manner of service. Regulation 33 inserts a provision that deals with the appeals and the reviews. It requires the clerk of the court to maintain a register for appeals and reviews to capture all notices that relates to the appeal and the review and the outcomes thereof. This is intended to particularly deal with what is currently the unfortunate practice where all the notices of appeal and reviews are mixed together. Even the notices of appeal and reviews relating to civil matters, those in practice seems to be put together and filed together. So the intention here is to make sure that the reviews and the appeals that relate to domestic violence are put and kept aside from the civil notices. Regulation 34 provides that the court may make an order after consideration of such proof as the court may require, directing the state to pay the cost of any service in terms of the act or the regulations, if the court is satisfied that the complainant or respondent or both of them do not have the means to pay for such cost at the time when service is required. Regulation 35 is one of the provision that requires the provision of legal aid. What we have done in terms of this regulation is to make the regulations that are currently used by Legal Aid South Africa to be applicable in relation to the provision of legal aid relating to domestic violence matters. Regulation 36 repeals the existing regulations. I did mention that the intention of these new regulations to repeal the existing ones of 1999. So these regulations are going to be replaced by the new ones. And there's a provision that anything done under the provisions of these existing regulations and which could have been done under the provisions of the new regulations is regarded as having been done in terms of the new regulations. In conclusion, the Deputy Minister has indicated the intention and the pressure that exists in terms of the putting into operation of the Amendment Act on the 31st of July by the President. Hence, we have this deadline of the 8th of July. And the stakeholders are requested, especially those who are working in this space, that is the space of domestic violence, to assist in terms of giving the inputs. That is my email address there, so as to improve these draft regulations. And because the stakeholders are the people who are on the front line in terms of getting to know more than us as legislative drafters as to what is happening there. They are the ones who get in touch and in contact with the victims, and they are able to assist in terms of improving these draft regulations so that we close the gaps that exist there, so as to make sure that the victims and complainants of domestic violence do get the assistance that they require, and that the Act is intended to give in terms of protecting them against acts of domestic violence. With this, I thank you for the opportunity to give this presentation, and I give back to the moderator, Ms. Yakivesas. Thank you very much.
Thank you very much, Mac, for a very useful presentation that I see everybody would like. I've also posted Luwando from Advocate Kambula's office email in the chat, and I will do it at the end again, if where you can also request the presentation, and if you don't have the draft regulations and forms and would like to have a quick look at that, we can do that as well. I see there's already a request, Mac, that the deadline be extended until Monday, the 11th of July. There had been also a number of questions dealing with the readiness of SAPS, concerns about implementation from SAPS perspective, and a variety of other questions dealing with SAPS. This is the first in a series of webinars, and there will be various webinars for the rest of the month coming that will be presented from the various different stakeholders, including SAPS. So if we're not able to adequately address any of those questions at this time, there will be further webinars, and as I indicated, from the various different stakeholders, including SAPS, where they might be in a better position to deal with some of the questions that has been raised in regards to the readiness of SAPS. With regards to the questions, there's been questions from Claudia and others about the monitoring of the online portal, whether it's one person or several, and do they then send the protection order applications to the relevant court along with proof of having done so to the complainant. I should maybe mention, Claudia, the way the online portal will work is that when you submit the application, there's obviously certain information that you need to give, including specifying which court you would like would be the most convenient for you in respect of dealing with your application. That will then enable the portal to send it directly through to that specific court. So it is not as if all the applications will only go to one specific person that would send it on. The portal will send it through to the correct court as indicated by the person submitting the application. Mac, part of the questions that has been asked here is about consequences and how will, through the legislation and the regulations, there be insurance that those that is to respond, and whether or not there would be any consequences to the failure to deliver or perform as provided for between the Act and the regulations. Would you like to go a bit more into detail in regards to the consequences for not complying?
Yes, thank you very much, Ms. Vessels. What we have done here is that, and that emanates from the Amendment Act itself. Section 18B that I spoke about. I did mention that it requires that the various departments do come up with the directives that are going to be followed by the functionaries within those departments. And one of the provision in that section is that those directives must make a provision for disciplinary measures, and specifically adequate disciplinary measures must be taken against a person who does not comply with those directives. Also, the Deputy Minister has mentioned in his introduction that the Director General has prepared the directives for clerks of courts. Those directives also require a provision be made. They do provide for disciplinary steps to be taken against the clerk of the court who doesn't comply with the what is provided in terms of the Act and obviously the regulations. So there is a provision that requires disciplinary steps to be taken against an official or a person who doesn't comply. Thank you very much.
Thank you, Mac. And just to follow up on that, there's also a question or request that you can kindly confirm which departments must develop directives and also by when these directives must be completed. From Petronella.
Thank you very much, Ms. Vessels. Petronella, the section that is relevant here is the very section 18B that requires the Department of Health, the Department of Social Development, the Department of Basic Education, Department of Higher Education and Training, the Department of Communications and Digital Technologies. These are the departments that are specifically provided for in this section 18B2, 18B1, in terms of which the directives must be made. Now, the section 19A of the Act is specific or set out as to when must those be completed. Now, it requires that they must be submitted to Parliament within 12 months of the assent to the Amendment Act by the President. So in terms of the fact that the President has assented to the Amendment Act on the 25th of January this year, essentially the due date for the submission to Parliament must be latest 24th of January 2023. However, there's a little spin on that, because now there's a date that has been set for the 31st of July 2022 for the operationalization of the 3 acts. Let me talk about all 3 of them. Now, whenever an act is put into operation, all the salient features that accompany the act, for instance, in this case, the regulations, the directives, the tariff, must be in place, so that when the act comes into operation, all of these things must be in place. So I will refer to everybody, and especially the is it Petronella who is asking this question? I'll refer you to section 18B1 in terms of the departments, and also section 19 capital A in terms of the day on which the directives by these various departments, including the directives for the clerks of the court, and even the submission of the regulations by the minister to Parliament. There's a time set there. However, I will also refer to the speech of the president in terms of which these act, or specifically the Domestic Violence Amendment Act, must come into operation, being the 31st of July. Thank you.
Thank you, Mac. Mac, there's a question about if a protection order has been applied online, how is it going to be verified and delivered to the respondent? The person asking the question is saying they're concerned about people living in rural areas where it's difficult or expensive to get to the court or police station.
Yes, thank you. That's quite an interesting question, and we know, all of us, that when we come about this electronic stuff, the people in the rural areas will somehow become disadvantaged in terms of this electronic stuff. And now, in terms of what we are coming up with, there will be an electronic portal in terms of which an application can be brought on that platform. Now, when that is submitted, then the system, obviously, then the electronic system will be designed for the identification of where the application is supposed to, or to which court it's supposed to go. Obviously, the platform, as far as I understand, there will be a selection of which is the court that will have jurisdiction that is going to be selected by the complainant on the platform. And that application will be channeled to the correct court where it will be processed, right? And that is where the online application applies, right, on the portal. Also, you remember I did mention that there's also a manual submission. We are not doing away with the manual submission because we know of the problems that are always encountered with this electronic stuff. Now, manual applications will always be accepted, and those who are not able to do the online the submission online on the portal, or even electronically in terms of maybe then the submission of the application to the correct court by way of, for instance, email, or even by way of a fax, they are able to submit that by way by hand, physically to the clerk of the court. So I will not have a suitable solution for that, except to say that if there are challenges in terms of online application, then there will still be manual applications that will still be accepted in the court. Thanks.
And the service of the protection order, I think that is linked to the question as well, Mac. The actual service of the protection order can be done in various different ways. The fact that it was an online application doesn't mean that it will be only served online. Am I correct? If you can maybe just clarify the service part too.
Yes, that's correct. The clerk of the court, when they receive an application, for instance, for a protection order, they will do the necessary in terms of the registering of that application, allocation of the case number, which is going to be an identifier of that specific case. And once that has been done and processed by the clerk of the court, it will be submitted either to the sheriff for service, or the police station, or even the clerk of the court themselves. Now, they have got those various options available for the service. They can do that service by hand, or they can do that electronically. So we have those options available, so as to enable the service of the application, especially in this instance, and even to ensure that there are those various options that are available in terms of which service can be effected. Thank you.
Thank you. There are some questions about clarification in respect of Section 2, capital B. The one relates to what about instances where the complainant, for various reasons, do not want to open a case, but it is known by the community or the family members or others that there is domestic violence taking place. How can, what can be done in those instances? And there's also another related question on Section 2, capital B, from Lindiwe, that she feels that it's still disempowering to the community of those suffering with sight impairment. They're of sound mind, but they can never prove beyond shadow of a doubt and avoid hearsay evidence. How do we incorporate them as individuals to present their case for substance in the absence of any witnesses?
Thank you very much. Chair, the last part of the question, I didn't get. I think my bandwidth was failing me. I didn't get that much. But with regards to Section 2A, 2B actually.
2 capital B.
That relates to the report by an adult person of incidents of domestic violence. Yeah, what we have done there, we have by way of an improvement in the Act itself as it currently stands. We are aware that people are afraid of reporting the incident or their exposure to domestic violence, and because of that failure or of being afraid to report, they fail to report, and as a result, they continuously remain victims of domestic violence. So now, this provision is opened there for those who have knowledge or suspicion that and there must be a reasonable suspicion. I must highlight that. You cannot just suspect for whatever reason, but that suspicion must be a reasonable one to say that a particular person is seemingly a victim of domestic violence. So this provision has been inserted to assist those who will be afraid or who are unable to report incidents of domestic violence, that those incidents are reported to the police or the social worker, so that at least then they are somehow assisted without them being seen by the perpetrators as the complainant. Because now, if a victim goes to the court and apply for a protection order, that on its own becomes a problem. The victim or the complainant becomes victimized for the mere fact of applying for a protection order. So now, if they don't apply, then there are those who are aware that they are victims of a protection order. They can be able to apply on their behalf. But now, here's the catch. The civil society were opposed when we promoted this provision. They were opposed to a provision that required members of the public to report incidents of domestic violence that are perpetrated against an adult person. You will see in that section, section 2, capital B, that those adult persons should be able to report incidents of or suspicion of incident of domestic violence perpetrated against a child, an older person, or a person with a disability, to the exclusion of an adult person. So we have restricted it to those instances. Hence, we are saying if people are aware of that and then they fail to report, they face being charged. This provision is trying to prevent the so-called bystanderism, in terms of which people are just watching over, seeing that a fellow citizen is exposed to domestic violence, and that victim does not do anything, and even the members of the society do not do anything. So this provision enables them to be able to report on those incidents. And also there's a protection to those who do report those incidents if that report is submitted in good faith, and they won't be charged or they won't be subjected to any form of civil litigation or criminal processes against them for the reporting of those incidents, although that is done in good faith. And that's all about that. And then, Chair, with regards to the other part of the question that I did not get, I will request that you perhaps repeat that. Thanks.
Thank you, Mac. It was from Lindiwe that she stated that section 2B2, that she feels that it's still disempowering to the community of those suffering from sight impairment. They are of sound mind. They can never, however, they can never prove beyond the shadow of doubt and avoid hearsay evidence. How do we incorporate them as individuals to present their case with substance in the absence of any witnesses?
That is a tough one. You remember the court are able to admit hearsay evidence, especially where it is relevant. And obviously then the court can be able to disallow hearsay evidence. So now, that is a very important question that is being asked here. And obviously, we are trying somehow to encourage those who should have reported, especially the victims, who should have reported, and they are not able to do that. Then someone take a step to report on their behalf. It will be in an ideal world when that case has been reported on their behalf. that they avail themselves in court, because what will have happened is that an application will be brought on their behalf, and if the court issues a protection order, then the victim will be protected. And if that victim share the same residence with the respondent, then that's when the simultaneous application for a safety monitoring notice will apply. It means, therefore, they will be protected against the respondent immediately, and also the safety monitoring notice will kick in terms of which a member of the police will be assigned to regularly check on the safety of the victim in this instance. So now, if someone else has opened a case on behalf of the victim will be protected in terms of the interim protection order and also in terms of the safety monitoring notice. So at least there will be some sort of encouragement for the victim to avail themselves to be able to attend court if they are able to do that, so that at least the case that has been brought on their behalf can be substantiated by the victim, obviously who have the first-hand knowledge of the facts relating to their exposure to domestic violence. However, that it is quite true that if they are not available, or if they do not avail themselves to court when the case has been opened on their behalf, it is unfortunate that if the court does not accept the hearsay evidence, then it is unfortunate that the court may not accept, maybe then they may not grant the final protection order. However, it's not in all instances that it will be hearsay evidence. The person will have witnessed themselves, and then they can be able to testify that on such and such a day, this is what happened. And then I realized that the victim is not able or is afraid of reporting the incident, and then that is why that member of the society took it upon themselves to report on their behalf. But if perhaps in those hearsay instances, the victim perhaps may have whispered or even may have told that person to say that, look, I am victimized on a daily basis. I'm afraid of reporting this. And then that person to whom this information is being given takes guts to approach the court to apply for their for the protection order on their behalf. Then obviously those people have taken a major step to the assistance of someone who is a victim of a domestic violence. And it's a domestic violence as it is, because it happens within the confines of the homes, where people are not easily able to identify the real exposure or incidents of domestic violence. However, that question is very important. If there's hearsay evidence, if the court does not accept it, it is unfortunate that the case may collapse. I will not have a different or an alternative solution to that. Thank you.
Thank you, Mac. Mac, you mentioned safety monitoring notices. There's quite a couple of questions in regards to safety monitoring notices. Whether or not, or how it will be made practical, how you would hold the assigned SAPS member accountable if they're not complying or delivering the service to the complainant. Also, if provision are made for the intervals for submission of the safety monitoring notice reports. There was also concerns about the just lack of resources and the capacity to ensure that the safety monitoring notice services will be delivered.
Yes, thank you, Ms. Vessels. You know, these are very important questions that are being raised. And I am hopeful that the stakeholders who are in this platform will be able to also, when they submit their comments, will also give us some form of suggestions or solutions, potential solutions to these questions that have been raised. The safety monitoring notice is a new invention. We don't have any precedence in terms of how it operates. It's a new invention, and we do not know, especially myself. Let me talk about myself here. I do not know how successful it will work. However, I consider it as a one step further to come to the assistance of the victims of domestic violence. Now, as a starting point, once the court issues that, and obviously then it will be issued in those instances where the complainant share the residence with the respondent. So now, once that is issued, then the clerk of the court will submit that to the police station. The station commander will assign a dedicated member of the police, who is the one that is responsible for that particular case. Hence, we have come up with a form of a report that will be filled in by that particular member as to the activities they have undertaken in relation to that assignment, and that report must be submitted to the court. So it will be a form of accountability of that member to the court. However, also in section 18 capital B that I've talked about, it requires that there should be adequate disciplinary measures that are incorporated in the directives, or in the case of the police, the national instruction of the police. So failure to comply, then those disciplinary measures in those national instructions will kick in. However, the court, we do not have a provision that will hold the member of the police accountable for maybe their failures, because obviously that is those members are not under the supervision of the courts, but they are under supervision of their station commanders. Hence, the national instructions then will have to incorporate the requirement that disciplinary steps be taken against the member who failed to comply with what is contemplated in the regulations relating to the safety monitoring notice. And I am hopeful that our police will try their best to make sure that this mechanism is used optimally, because it's one of the steps that we are putting out there for the protection of our members of the society. And it is incumbent on the police to at least make sure that there's compliance with this. And the success of this measure will be in the hands of the police. And unfortunately, we do not want to see our members of the police being subjected to disciplinary proceedings or maybe disciplinary steps being taken against them because of their failures, and because they will not only be failing us as the society, they will be failing in their duties as members of the police. And worst of all, they will be failing the very victim who is to whom these measures are intended to protect. With all that, Chair, I do not know if I missed something.
Yeah, Mac, I think there's quite a couple of questions that comes down to, but if the police is not doing their duty, who can the victim report to? If the police is not complying, or is, for example, the one is, if the safety monitor becomes a perpetrator being bribed or threatened by the original perpetrator, where can a victim report where the police is? There was also some questions of, but what if the police does not serve the protection order, where the perpetrator is known to the police and they warn them before the time, before they came to serve, etc. Where can a victim go and report such?
Well, Chair, unfortunately, I cannot take it any further than that. Because in terms of the Act, obviously what is happening here, it should be within the confines of the Act. And now the Act is saying the police must activate this safety monitoring notice, and the regulations are coming up with the procedural steps, if I may call them that, in terms of which this safety monitoring notice can be given effect to. And now the national directives that will provide for the disciplinary measures. I can take it as far as that. However, this is one of the important questions where everyone in this platform may have to assist us, because it's a very important a submission or question, I might say. And now we have to come up, put our heads together in terms of submitting alternatives as to how this can be kept and how to make sure that this unique and a new innovative measure become a success for the protection of the victims of domestic violence. Thanks, Chair.
Thanks, Mac. I see Claudia in the chat had indicated that failure to comply by the police, that would be the station commander or the civil secretariat or the police or police ombudsman. And her suggestion is that their directives should include those numbers. Claudia also had indicated that she received the forms for the consultation and whether she could suggest already that the National Shelter Movement of South Africa's helpline for referral to shelters be added to Form 4, that is the list of accessible shelters and public health establishment, alongside the shelter numbers. There's a number of questions in regards to people with disabilities. I
don't know, Chair, if I lost you. Are you still there?
Yes, sorry, I'm just trying to get them all.
Oh, so sorry. I thought maybe then I got disconnected. Yeah, maybe then you can check those that just by way of
there was one that was about a reference to people with disabilities, and that adults are also that adults can also be people with disabilities. I think maybe some clarification is that there might be some concerns about whether or not it's quite clarified that when we're talking about people with disabilities, that is not just children, but also adults. And that I see there's also the reference to the Gender-Based Violence Command Center by the National Department of Social Development that can be utilized with its toll-free number with concerns. And that this is where IPID and the civilian secretariat can play a role. there was a question as well about whether or not a pregnant woman and unborn children are included in the groups that are protected by the Domestic Violence Amendment Act and the regulations, and if so, which regulations cover it?
Well, thanks, Ms. Vessels. I can maybe try to respond to those in the meantime.
Yes.
But by way of a remark, in terms of where the member of the police can be reported, it's noted where those institutions, the ombuds of the police, where the members of the police can be reported for their failure. And obviously, because members of the police are subject to those institutions and even the ombud, then in case of a failure to comply, then obviously then those institutions will take over in terms of taking steps against a member, because obviously then that member will fall under the jurisdiction of those institutions or the ombud. And hence I was saying they are not within the jurisdiction of the court, and because the court cannot do anything, at least as far as I can see, they cannot do anything against those members. What the court is required of the member is that the member must just submit a report in relation to their activities in as far as that safety monitoring notice is concerned. So I'm glad that at least we have a response as to where a member can be reported, and even we won't include this in the regulations, because it's what applies, is already applicable in practice in as far as the members of the police are concerned. Now, the issue of the reporting on behalf of an adult, I must say it was a very hot potato in the pot. We were challenged left, right, and center by members of the society, or especially the civil society groupings. They were totally against that, and we already had a provision specifically for that. And as a result of a multitude of opponents to that, we had to take out that provision. Hence, we have restricted it only to those specific categories, in respect of whom domestic violence or protection order on application can be brought. Specifically, can be brought on behalf of, or where there is suspicion of incidents of domestic violence relates to a child, an adult person, an older person, or a person with a disability. Now, an adult person who is a person with a disability is covered by that. Because you remember, these are a category of people we regard as vulnerable groups. And if nothing gets done to their rescue, then we will become a lost society. Hence, we have confined to this, to the exclusion of an adult person who is not with a disability. So obviously an adult person with a disability is covered by this. So incidents of domestic violence against them can still be reported in terms of the Act.
Thanks, Mac. Mac,
can I?
Sorry, yeah.
Just a pregnant person. Obviously, then The protection order will attach to that person, and naturally it will cover the pregnant. I don't know how to answer this, but
yeah,
the pregnant person will be applying for a protection order for themselves, and automatically that will cover. I don't know. The pregnant person will be protected. I don't want to take it further than it will maybe then raise eyebrows. I will leave it at that. The pregnant person.
Thanks, Mac. We've still got a lot of questions, and we're definitely not going to get to all of them before our time runs out, but there's a couple that I just quickly want to put to you. One of the concerns about the protection orders that's not issued or served by SAPS on time after being granted, and then victims come back and then it's not being served. What do we do in these cases? Is there anything in the regulations in regards to where it's not being served on time? And there's also a related question that the returns of services, how that would be monitored. And between the sheriff and the police in order to deliver the summons electronically, or will the tracking system be sufficient? And kind of related to that is also whether the amendment grant the court powers to order the state to provide complainant and witnesses with transport fees where necessary.
Thank you, Chair. The issue of the last issue, maybe then if I can talk to it quickly, of the witness fees. We don't have a provision in the Domestic Violence Act itself, and I believe the Magistrates Court Act will kick in terms of the provision of transportation for witnesses, including witness fees. I think that will be covered by that, because the Domestic Violence Act deals with or talks to the courts that are actually the district courts, which are the courts established in terms of the Magistrate Courts Act. So that act will be applicable, and it will be applicable in other instances which are not covered by the act itself. So that will be covered by that. The issue of timeous service, I must say once again, this is one of the hot potatoes in the pot. And you will have seen in the draft regulations, we have come up with the time frames within which certain things must be done, and particularly in relation to the police, because now we wanted to make sure that things are done as soon as possible, especially when things come from the clerk of the court. The clerk of the court must do whatever they are required to do, like submitting to the police as soon as possible. And that time frame must be complied with, because the important thing is the safety of the victims and also the nature of this protection. Obviously, then the whole purpose is to protect the complainants. Now, if we don't comply with these time frames, we put them in further danger. Now, hence these time frames are important. Also, the police, when they receive these documents, we have certain time frames that are set within which those activities must be done, and other time frames may be restrictive, may be perhaps difficult in as far as the police are concerned. But we are saying, look, let's hear from the police, because we are trying to make sure that these are attended to as soon as possible. And the police can be able to say that, look, this one is difficult to comply with. At least we are suggesting this. this time frame. At least if the police can give us those time frames, we can be able to have a look at that. And even not only the police, the civil society groups can also suggest suitable time frames, because they are the ones who deal face to face on a regular basis, if not a daily basis, with the victims. And they are also in a better position to be saying, by way of a suggestion, to say that the suitable time frame for the police to do this is this instead of this. So coupled with what we will be receiving from the police, we can be able to come up with a common ground in terms of which we will be saying this is the suitable time frame for compliance with this, with a particular time frame. So now, a time-wise service is very important. And with the advent of the electronic stuff, where all these activities will be taking place, I would not want to preempt how the system is going to be like, but we know the system can be designed in a manner which the clerks of the court will get notification, perhaps a reminder that this should have happened, you should receive this, maybe then a return of service, because of the time frames within which the police must respond to the clerk of the court. Then, if the system can be designed that way, then the clerk of the court can be able to monitor the compliance or non-compliance with the service of a particular or a certain document by the police or even the clerk of the court. Thank you.
Thank you, Mac. Unfortunately, we've run out of time. Mac, there was another request as to whether or not there's a possibility of an extension for the comments until Monday. I have put your email address again in the comments in the chat section as well. Is there, Mac, would you accept comments until, yes, and then I would like to hand over to the Deputy Minister.
No, I was going to deal with the extension issue.
Thank you.
So is there anything you want to ask back? I do the closing or whatever.
Deputy Minister, we've run out of time, so I am going to hand over to you for the final word.
Okay, no, thanks very much, everybody. Sorry we ran out of time, but this is the first of a number of sessions. There've been a number of, this was a general one, but specifically on the Domestic Violence Act. But there are there's one specifically targeted for the police, which I think is hoped to be happening next week. Well, there's a couple specifically targeting the police. I think there was a suggestion about the civilian secretariat who do have responsibilities, statutory responsibilities in terms of the Domestic Violence Act and the, and IPID. IPID, though, is more about people being killed or assaulted by the police. So I'm not entirely sure whether they would come in. The police ombud that was referred to, I think that references to the Hawks ombud, which is specifically relating to the functions of the Hawks. But just on the issue of the extension, I did consult Kale Pillay, who's the DDG for Legislative Development, Mr. Makulubete's boss, and I think she'd also spoken to him. People can submit on Monday, but by the morning, by 10 o'clock, so that because the issue is these regulations need to be promulgated before the end of this month. So if the department don't have enough time to work on the submissions, I think it would be useful also to to have further, once everything is in effect, to have further further webinars, maybe for particular sectors. I think somebody was online asking about students and so on. So one could maybe pick particular sectors, but once everything is finalized, that's more of an educative sense. There was an issue around translation into the different languages. I think that's very useful. But again, if legislative development can look at the cost of that, otherwise at least a summary of the act, because sometimes acts are not particularly user-friendly for ordinary people. So those are just my comments. Yeah, just maybe one other point. A number of people, both on the question and answers and the chat, were putting up their email addresses, wanting a copy of the presentation. On the chat, and it was put up to please send your email address to Luando Dikweni, capital L, capital D, IKWENI @justice.gov.za. I think they are trying to, Luando is trying to capture all the email addresses, but just please to make sure, contact her as well, just in case yours gets missed. And then the regulations are on the Department of Justice's website. So the documents can be got from there. But I think then in closing, if this is the last word, to thank everybody for participation, for their questions, their comments. I think it's been a useful engagement on this issue. And please keep an eye out for the future webinars. Thanks very much, and back to you, Mrs. Wessels.
Thank you very much. I would like to thank Mac for his presentation and the Deputy Minister for his input and introduction, as well as the team behind the scenes that arranged the links and the invitations, and Advocate Kambula and her office, and Luando. If there is a reminder of Luando's email address as well. Luando normally sends out the invitations as well for the future webinars. So please make sure that you communicate with him if you are interested and or did not receive. There will be a webinar tomorrow dealing with the impact of the amendments on intermediaries at 2 o'clock. And on Friday, we will have a similar webinar as this one this morning, also at 9 o'clock, where we will again brief everybody about the draft regulations. So if you have other people that were not able to attend today, they would be able to attend on Friday. Please make sure that you send your comments and inputs through to Mac, as they really are important. At this time, I'm going to say thank you to everybody and goodbye. Have a lovely day further, and we're looking forward to further comments. The comments that was made on this platform will be taken into account by Mac and his colleagues as well. Thank you, everybody. Goodbye.
Thank you. Thank you very much, Yaki. Thank you, everyone.
Thank you.
Thanks, Yaki.
Thanks, Praise. And strong to Luando.
All the responses that I have been making have actually gone to people.
Oh, yeah, I hope so too. Thank you.
Thanks, yeah.